All right, so my name is Susannah Baruch. I'm the executive director of the Petrie-Flom Center. I'm pleased to welcome you today to this event, a conversation between Professor Dov Fox of the University of San Diego Law School and our very own Professor Glenn Cohen. The Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics is, as our very long name suggests, a multi-issue, multidisciplinary health law research center here at Harvard Law School. Currently, our work spans legal and ethical issues such as psychedelics, medical AI, aging and healthcare, and embryo law and ethics. Please visit our website and subscribe to our newsletter, which will keep you notified of all future events like this. So let me take a moment to thank the incredible Petrie-Flom Center team. I think Lisa Gorelick here, Laura Chong running around, and Erin Scott, who many of you met on your way in. I want to say, too, thank you to Professor Fox for coming to this event. This has been a big week, as he has been in great demand around Harvard University. So on Wednesday, he was at the Harvard Medical School delivering the Lawrence Lader Lectureship on Family Planning and Reproductive Rights. On Thursday, he was the keynote speaker at the 2026 Moral Leadership in Medicine convening. And so I would like to say he has excelled through 2 rounds already. And today we have him here at Harvard Law School for what we'll call our showstopper final challenge. Professor Fox is the Herzog Research Professor of Law at the University of San Diego, where he directs the Center for Health Law Policy and Bioethics and has been named University Professor, which is the university's highest academic honor bestowed on faculty in any field. He's produced 3 research documentaries, published 4 scholarly books, and over 80 articles in leading journals of law, medicine, and public health. His research has appeared in The Atlantic, The Economist, Foreign Affairs, New York Times, and The Wall Street Journal. And his audio series, Donor 9623, was named Audible's Podcast of the Year and nominated for a Pulitzer Prize in investigative journalism. So his book, The Conscience of Care, Navigating Health in the Culture Wars, could not be more relevant or more timely. In it, he meticulously describes a stark asymmetry, a clinician's conscientious refusal, as many of you know, to provide certain aspects of healthcare gets legal protection, while conscientious provision of prohibited care does not. So this book intriguingly flips our understanding of conscience by engaging a wide range of care to consider, from pain relief to medical aid in dying. And Professor Fox urges us to reckon meaningfully with our deepest values and consider how conscience and that concept might play a more equitable role. Once Professor Fox concludes his initial remarks, he will be joined by Professor Glenn Cohen, the James A. Atwood and Leslie Williams Professor of Law and Deputy Dean and Faculty Director of the Petrie-Flom Center here at Harvard Law School. So thank you very much for coming, and I'm going to turn it over to Professor Fox.
Thanks, Susannah, to Laura, to Lisa for organizing, bringing us all together here today. Obviously, the incomparable Glenn Cohen. It's a special pleasure to be with you to talk about a project whose seeds were sown in conversation with law students like you here in Glenn's class on health law and policy. So to be back now that this idea has grown up a bit, it is wonderful to be back in dialogue with y'all again. I'm very grateful for a chance to talk with you this afternoon about the medical conflicts that divide us. I want to consider the lost promise of a contentious ideal, conscience. It goes back to the first ethics code that the American Medical Association published in 1847. The AMA said that medicine's core mission to care for patients draws its moral force from a physician's conscience. It's a concept with renewed meaning today, when clinicians have never faced so many restrictions on whom they treat or how. In September of 2021, a Texas law called SB 8 banned abortion after about 6 weeks. Days later, Dr. Alan Braid confessed to having violated that law. His op-ed in the Washington Post explained that back in June of 1972, he had been a young OBGYN resident in San Antonio for 6 months before Roe v. Wade legalized abortion nationwide. In that short time, he witnessed 3 teenagers die from self-induced abortions after the state had forbidden them from getting those safely. One of them arrived to the ER already septic, her vaginal cavity packed with rags. These memories haunted Dr. Braid. He warned that preventable deaths would return, and sadly they have, since the Supreme Court overturned Roe exactly 50 years later in June of 2022. A dozen states quickly joined Texas to ban abortion at 0 weeks and impose harsh criminal sentences for providing one, up to life in prison. Braid was adamant that this time he could not just stand idly by. So he broke the law and accepted the barrage of lawsuits he knew that he would face. For Braid, this wasn't just a matter of meeting his professional obligations. He made clear this was about his conscience, his deeply held moral beliefs. All right, so why value clinician conscience? What's so special about an individual's deeply held moral beliefs anyway? There are 2 reasons. The first is for the sake of the individual who claims it. Protecting conscience preserves the moral integrity that spares a doctor or nurse from trauma or burnout, what we call moral distress in medical ethics, if they're forced to practice medicine at odds with their convictions. Second, at a social level, respecting conscience protects and promotes the kind of pluralism that enables a dynamic profession like medicine to embrace its moral diversity and adapt to moral change from within. Federal and state conscience clauses have crept out since the 1970s. Today, to, as Susannah mentioned, shield clinicians who invoke things like the sanctity of life, the dignity of marriage, the unity of sex and gender at birth, to protect people who refuse standard of care treatment, to turn patients away, even in ways that their profession, their employer, or their state requires of them under employment policies, breach of informed consent, or malpractice, even negligent homicide laws. They are shielded even from criminal penalties if they invoke conscience to refuse care in ways that violate these rules and harm patients. They don't lose their job or their license to practice. They can't be held liable for those civil or criminal penalties. Conscience clauses don't just shield individual providers, but whole institutions, corporate healthcare conglomerates, and individual non-clinicians who object from a distance, refusing, for example, to check in patients at the hospital if they're going to seek an abortion, or file their insurance claims for end-of-life issues. Yet there's no protection for clinicians whose conscience compels them to provide medically indicated care. They get no relief to treat patients in beneficial ways that honor their wishes, don't override them, as is often the case with refusers. Providers like Braid get fired, sued, even prosecuted under the threat of decades behind bars. Conscientious objections are governed very differently in the military. Objectors are exempted in this context from battle only if the country can field the fighting force without them. They get exempted only if our military needs more broadly may be met. And those who do get an exemption still have to pitch in to make up for opting out. So if others are drafted and they are not, they have to do something to serve the cause that they are not a part of. So for example, in the Civil War, objectors had to pay $300 to recruit replacements for themselves. In Vietnam, they had to serve as combat medics or civil volunteers and other roles for at least as long and as difficult as combat service would have required of them. In medicine, by contrast, refusing clinicians get a free pass, no conditions to meet the medical needs, so even if denying care would leave us unable to meet basic medical needs. They don't have to do anything for claiming the privilege of conscience either. They get conscience, in other words, without conditions or consequences. So here's the question. Can this radical asymmetry in our conscience laws be justified? I want to consider three arguments I think are the strongest available to help make sense of this radical asymmetry. And to preview, I don't think any of them do the work required of that disparity in our laws. First, this argument is that forcing refusers to provide the care that they morally oppose is worse than making providers decline to treat patients as their conscience commands. This distinction between doing and allowing, it looms large in life and in law. You can't push someone off a bridge, but you're allowed not to save them from drowning. This moral difference between doing and allowing matters less, however, in the practice of medicine, where providers have a special relationship with patients, something like the way that parents do with their children. Things like information and power disparities between them and special obligations that we as a society think ought to be required of caring for these particularly vulnerable people impose more than just negative duties to refrain from, say, performing ill-advised surgeries or prescribing dangerous medications. As with parents, clinicians have positive duties too. They have to undertake affirmative measures on behalf of their patients to preventive screenings, for example, and a host of treatments that are required of them in order to comply with medical standards of care, lest they be punished for malpractice or breach of informed consent for failure to having affirmatively shared with patients about their medical options. In medicine alone, maybe other than parenting, in these domains of life, the line between doing and allowing that usually does a great deal of moral and legal work, it can't justify this legal asymmetry between protecting conscience for refusing care and allowing it, or providing it, rather. Argument two, it's a lot more practical. It just costs less to accommodate refusers, right? They're not asking third parties, like states or hospitals, to pay for the expensive facilities or equipment that would be required to make room to provide care that they'd rather not and otherwise wouldn't. A couple things. Lots of prescriptions that people might conscientiously provide to patients against the rules, birth control, puberty blockers, medical marijuana. These are pretty cheap. What does that cost? A prescription pad, an entry in the medical health records? Also pretty inexpensive is a conscientious provision of a tubal ligation that would follow an already scheduled C-section. It just doesn't cost that much for a little extra anesthesia or a few extra minutes in the OR that you're already using. But lots more procedures are pricier, of course. But these, at least some of them, might, while pricey, cost less than the alternative. Consider, for undocumented immigrants with chronic renal insufficiency, kidney disease, the standard of care is called regular dialysis. It costs a lot, but it's less expensive than going without it, and thereby necessarily needing a far more expensive emergency form of dialysis once your kidney inevitably fails for lack of the regular dialysis. And so physicians, some conscientious providers I've spoken with, face the question, should I miscode an undocumented immigrant's medical chart, which is like fraud under Medicare rules, in order to qualify them for funding for regular dialysis before they would qualify in the emergency when it's too late and would also be more expensive? Hey, if costs are the issue, then should it matter that a conscientiously provided abortion costs less than the labor and delivery costs that would be imposed by a conscientiously refused abortion? Finally, refusals aren't cost-free. It's expensive to accommodate those as well. Externalities get imposed on patients who have to travel or wait or go without care. Also on coworkers who have to cover for colleagues who refuse the care that they'd have to step in to provide, extra hours, extra work. Also on institutions that lose staff, and on regions that experience care deserts, and on states and hospitals that have to enact backup measures in order to recruit willing providers or somehow make up for the fact that some of their staff is unwilling to provide basic care to those in need. So I don't think these cost differentials can explain why it is that our laws protect refusers so much and providers so little either. Third justification is, I think, the strongest of the three. It says that accommodating refusers is consistent with a background policy, this interest in making care available that a state or hospital might have, because non-objectors can always step in, at least in theory, right, to provide it. You can accommodate refusers and still have care available like the hospital or state wishes it to be. By contrast, when a state or hospital restricts treatment, allowing anyone to provide it would seem like it can't help but ride roughshod over that policy interest in the care being made unavailable. But practical realities complicate this argument too. Where refusals are concentrated, or healthcare markets consolidated such that lots of religious institutions that impose restrictive limits act to limit the availability of care, widespread exemptions for refusers can leave that care functionally unavailable when a hospital or a state wants people to be able to access it. And under a regime that restricts treatment, we'll see how institutional workarounds and a partial defense for medical disobedience can make a measure of space for the provision of care without necessarily defeating the whole purpose of a prohibition. The law's radical asymmetry in sum is unjust and indefensible. So, why not abolish conscience objections altogether? It's not just that they're woven so deeply by now into the fabric of American medicine and law that it would be impractical to uproot them, although I think that's a reasonable point. It's also, and more importantly, that extinguishing exemptions wholesale would deprive medicine of its moral dynamism. It would say that in this practice area alone, only some moral beliefs are allowed and would exclude those permissible, even worth celebrating beliefs of many who practice in good faith and do good work, and the patients who want that practice available to them. I think that we should protect conscience for hands-on refusers too, those directly involved in performing work that their conscience forbids them from taking direct part in. But we should balance out these protections. Accommodate refusers less than absolutely, and protect providers more than not at all. So these claims operate along two dimensions, that is, two levels of authority. One is employment policies, Two is government laws. At the hospital level, a clinician's bona fide appeal to conscience should be accommodated, I think, so long as there are reasonable alternatives to allow for its exercise. But I wouldn't allow limitless exemptions that leave medically standard care unavailable to patients who seek treatment at that hospital, nor would I impose requirements for accommodating provision that would force a small, closely held religious clinic to shut down, thereby leaving unavailable, say, the natural family planning methods, a faith-based that a lot of patients who go there deeply value having access to. To offset the burdens on patient care, large sectarian hospitals who wish to restrict it but are made to offer accommodation for providers there should take a couple of steps to preserve access. First, easy one, eliminate the gag rules that many of them have in place that say that anybody who works at, say, a Catholic hospital can't even tell patients that their medical options, if those include anything from aid and dying to long-term contraception, emergency contraception, IUDs, IVF, Plan B, let alone abortion, of course, is a medically indicated option. So when a rape victim comes in, to let them know that if they act within 72 hours, there is treatment available to prevent a pregnancy from starting. They could also, these sectarian hospitals, set aside space within the hospital, either in-house or nearby off-site, where either conscientious employees or independent contractors or outside personnel could provide care using supplies funded from elsewhere. That is, to have a distance between the institution itself and the care that they oppose, but allow space for those who feel differently and patients who feel differently to be able to access that care in limited ways. Meanwhile, small, close-knit clinics should be free not to hire or to fire conscientious providers within their ranks in order to preserve their very identity that accommodating providers would override were they forced to accommodate them. And this stuff costs a lot. So I would suggest that they be funded not by objector fees on individual conscience holders, claimants, although that would be an option too, but rather because of the value conscience has to spread those costs among states or insurance premium pools writ large or large healthcare systems. One other workaround that a sectarian institution could establish by way of distancing measures is for the state to support, subsidize intermediary groups, so that if direct referrals felt like it made an objecting institution or individual clinician too complicit in the evil that they perceive by providing aid in dying or abortion or gender-affirming care, then have them in the alternative just give a contact number to a specialty organization like the American College of Obstetricians and Gynecologists, which would receive state funds to take on a new role as an intermediary matchmaker, so that patients could seek individuals who would provide care that their institution or their doctor is unwilling to provide, and also find unwilling clinicians whose refusals match their own values, to play this matchmaking role in ways that don't as directly implicate the kind of complicity concerns that often make referrals very complicated. All right, so much for the employment space. Let's turn from hospital policies to state laws. On one side are mandates to secure informed consent and avoid malpractice or patient abandonment. That's what our civil laws and some criminal laws require. On the other side are civil and criminal bans on providing standard care. Abortion, gender-affirming care. Supreme Court any day is going to tell us about bans on conversion therapy. crackdowns on high-dose opioids for chronic pain patients or in ICU settings, in a wide range of practices chronicled, a couple of dozen. In the book, we ban care or restrict it in ways that we just never have before. This is really quite new for American society. So I'm wondering how it is that we can value clinician conscience without imperiling legal orders. These are democratically enacted laws and rules, after all. They're rules about things that implicate deep moral values, impairment and identity, life and death. I propose a partial defense on legal violations to rules on restricting care or providing it in the name of conscience. Clinicians who break the law on conscience grounds would still be subject to liability or conviction. The defense would operate instead to substantially reduce their fines or prison time to a small fraction of what the penalty or punishment would otherwise be. Now, for refusers and providers, this conscience defense would come with conditions. 3 different ones each for refusers and providers, and they derive from the pillars of bioethics, things like autonomy, beneficence, doing right by your patients, doing good things for them, and justice collectively for society. So 3 conditions I want to run through. First, for refusers to claim this conscience defense to substantially reduce the penalties they'd otherwise face. Then for providers. All right, first thing refuser has to do to claim the defense is disclose their conscience objection in advance so that individual patients have at least a chance to seek care elsewhere. Also disclose it to their employer so there's not a surprise or workaround they have to do at the very, very last minute. So disclosure, openness. Second, they can't drop an existing patient, someone they're already seeing, actively providing care for mid-treatment, without saying to it that they have continued care from there. There is a way for them to find someone else through a referral or these intermediaries or someone else. So no abandonment either. They don't get the conscience defense to do that. Finally, clinicians, institutions can't turn patients away based on race, sex, age, disability, things generally that are prohibited by civil and federal and state civil rights laws, although these limitations are scarcer or more nominal, negligible than I think it should be a condition of claiming conscience to break the law and have lower penalties. So these 3 conditions to claim conscience are about notice, non-abandonment, and non-discrimination. So if you meet these conditions, and not if you don't, but if you do, then refusers could break the laws against malpractice or informed consent in ways that they're still held liable or convicted if it's a criminal penalty, but have those legal consequences substantially reduced, even if they violate their duties or harm patients. 3 different conditions would qualify conscientious providers. First, treatment must not coerce or exploit or deceive competent patients or their surrogate decision makers. So you can't conscientiously provide genital cutting for young girls if it's the case that she is bullied or pressured into that, not just by you as the conscientiously providing clinician, but by a family member or community group or faith. Second, compliance with professional standards of care and reliable evidence about risks, harms, and alternatives. The defense wouldn't be available to provide things like conversion therapy or ivermectin to treat COVID, that we and the medical establishment has well established is far more likely to hurt people than to help them. Can't claim conscience to provide care like that. Finally, providers can't hoard scarce resources just for their own patients at the expense of others who would gain at least as more from, say, costly dialysis or say, a paid-for organ that's in short supply. And by federal ban since '86, we forbid anyone from implanting an organ that has been paid for. But what if that's the only way to save a life? Your patient comes, you find out the organ was paid for, it can't be used elsewhere, it's going to go bad, it's not going to last, there's not another patient. Can you use that paid-for organ? What if you just do that all the time and now only your patients are getting those? That could implicate this distributive justice condition on claiming the conscience defense. So we've got patient agency, clinical reasonableness, and fair allocation of scarce resources. Those are three conditions to claim the defense for conscientious providers. Now this defense, in short, we haven't worked through the practicalities, but maybe we'll do that in the conversation, would raise, I think, three big challenges for American democracy. First, there's the risk of eroding respect for the rule of law by making exceptions anytime a refuser or provider pledges allegiance to a higher moral code. Well, sure, that's the law, but I don't want to follow that. That's a serious concern. It's why we rarely give any kind of legal exceptions for civil disobedience more generally. So what's special here? Well, not only, I think, that we have moral beliefs that are routinely invoked by virtue of medicine's intimate probing, high stakes, and matters of deep, profound significance to individuals. This is so often about right and wrong. But second, we can take the edge off this concern about rule of law with narrowing conditions, most especially the medical reasonableness condition. Right there we have a widely agreed upon standard of care, big asterisk, as we debate standards of care for things like gender-affirming care or conversion therapy right now, and the influence of politics or ideology in medical boards and elsewhere. So again, something to talk about more. But I think as a society, we generally think it's good for medicine to be able to help patients. And we think that it's good that there is evidence brought to bear to meet standards about how people get care. And so I think there is this agreed upon anchor that hooks the conscience defense in ways that mean the rule of law wouldn't be overridden in the ways that somebody just says, well, I want to break the rules because I have my own beliefs. This is something that I think we can all agree on, at least at a very basic level. And it's not just those narrowing conditions that limit this exemption from following the law. It's also the consequences that ought to be imposed, just like we do in the military context. So that would be the offsets that would apply to either individual clinicians, like an objector's fee, or to institutions or states to require them to have those workaround methods in order to pay a cost in order to exercise conscience. That is, to treat conscience not as an absolute right you get for nothing by virtue of who you are or what you do, but a special privilege that you have to earn or pay for in ways that recognize that, like in the military and medicine, we're all in this together, providing a special good that we want to make available to all. The second concern about democracy, will the defense be deployed in arbitrary or discriminatory ways, available only to groups that are favored or practices that we think are preferred? The conscience defense mitigates that risk by requiring claimants to allocate scarce resources fairly. Final concern is about the separation of powers. Can courts really slash an offender's sentence for providing the very care that the legislature has strictly prohibited? Yes. The conscience defense falls squarely within the judge's common law authority to reduce punishments based on things like duress, provocation, and diminished responsibility. We've created new defenses from the bench all the time. Things like self-defense, necessity, before legislatures often went on to codify them as a matter of statutory law. So I think there's plenty of legal precedent for establishing the defense for medical conscience. I think there's reason for hope in the history of medical conscience legislation, although it's been long ago. But I will stop here and welcome conversation with Professor Cohen and with you all. Thanks so much.
We'll jump right into it. It's a particular pleasure to be with Dov because this is a little bit of personal biography. When I started as a postdoc, it's going to be about 20 years this summer, I think, Dov. Dov was our first summer student at the Petrie Flom. So we've been at this a long time, right? Okay.
Let's fight.
Because time is short, we're going to jump right into it. And I'll start with the unkind version of the first response to it, which would just say, Dov Fox walks in here as a good liberal and says, this is not a political project, political valence, it's about conscience, it's about principle. But it's really kind of has a very strong political valence that the examples happen to always lean in the direction that good liberals like and against them. So it's truly not a liberal project. I'll say more about that in a second. We'll take this in two parts. And the second is it's like pitched as like a universal project, is to say, oh, I'm just going to generate these generalized universal principles that are good for abortion, good for opioids, good for conversion therapy, but quite hard to divorce one's views about the ethics or the moral valence of the particular issues and why I think it's universal. So let's start with the first critique, the liberal critique, which is to say, so again, smart guy comes in saying, well, conversion therapy, right? Here's a reason why that's different, that it has to do with the standards of medicine and the standards of practice. That's what justifies the exception. Except that those standards are themselves kind of generated by a merchant class of professionals. And actually, there's a lot of assumptions baked into that. Like think about the back and forth in terms of the various academies and reports and the Cass report when it comes to gender affirming care, right? It's not as though this is purely science. There's always normative baked in. There are questions about trade-offs between autonomy, religion, parental views. So the idea that we can pitch this as a project that kind of saps out the normative, except at the high level, the meta level of what is conscience, seems to me kind of surprising. So what do you say to someone who says you're just carrying out a good lefty project but putting in the guise of liberalism?
That's all I'm doing. No, I think that it is easy to have that reaction in our current political moment, and when in terms of how things might seem to align. But I think that they will not line up nearly so nicely if we zoom out and consider history and some hard cases that are with us today. Consider in the early 20th century, it was good lefties in the medical establishment, like Margaret Sanger, who would have mandated birth control for minority populations, who stood behind rules like Virginia's mandatory sterilization law, that we would prevent the feeble-minded and other unpopular groups from reproducing. The medical establishment stood behind, again, from the left back then, they would say we conscientiously would provide this care that we regard as within the medical norm and good for patients, and we would claim a defense if we were prohibited from doing that. It aligned with the laws at the time, but they would have said so. Medicine in general, as a rule, has evolved enormously, and not just because of emerging medical knowledge. Like, for example, we're currently learning more about the impacts of gender-affirming care for young people. We just don't have long enough studies for this population to know potential long-term impacts on bone density or fertility. That could change the views of left and right that are currently associated with promoting it, prohibiting it, allowing it, and so forth. But also, our very norms evolve. The 70s, homosexuality was a disease to be treated by medicine. That was the American Medical Association's official view. Today, we have a Supreme Court case pending about whether conversion therapy ought to be allowed. It's a free speech case, but it also involves medical standards and norms, whether the state ought to be able to enforce standards that would permit a clinician, a licensed clinician, to offer this therapy as a way to treat a disease. Here, too, we might invoke the conscientious provision that I am favoring in a way that I think would be contrary to evidence. I would like to think that it is genuinely that evidence and not just political beliefs that are dictating the outcomes here, and that it might flip based on new evidence or based on new norms. So the book talks about a lot of examples where I don't know what the liberal or conservative thing to do is. I also don't know what the obvious or easy answer is. I said that bullied genital cutting wouldn't qualify for that, voluntariness condition. But it might not be the case that young girls are bullied. What if a doctor knows that a girl is at risk of deep and dangerous genital cutting? The parents, the family, the faith, maybe she herself, an older adolescent, is absolutely going to do this in a way that could risk her life or her future ability for fertility or sexual function. And the doctor says, well, wait, hold up. If you come to me in my clinic using my training and sterile equipment, what if I provide a shallow incision that wouldn't impair your sexual functioning? And then that would be a reason why you wouldn't have to do this other more dangerous requirement. Should that be conscientiously provided? What about
should it, right? So it's not the question, the answer based on your view.
So here, and there are a number of other examples I think would fall within this category. There's a condition where people feel deeply alienated from their healthy limbs and seek to cut them off. And what many of these patients do without being able to is they will seek, again, kind of underground self-help measures that often take their own lives, either getting a provider who's not a real doctor, or just laying their limbs on the train tracks or shooting them off. Same with patients who don't have access to high-dose opioids to treat their chronic pain and are desperately suffering, and so break the rules by getting fentanyl off the street that ends up killing them. So here I would say the defense, none of these are within the medical norm, so they're not medically reasonable, but this is about harm prevention outside of the norm. And so I think that some things would be in and some things would be out. And for me, right now, and it could change, the high-dose opioids to treat chronic pain would be in, because that was pretty medically normal and standard until just about 2016, after I guess we're still in the midst of an opioid epidemic with real harm, obviously, for addiction and overdose. But we crack down way too hard in ways that I think has caused graver harm than we recognize for people who really profoundly have chronic pain and need medication, the only thing available to treat it. Things like shallow genital cutting or amputating a healthy limb to save someone from cutting it off themselves. Those, I think, would fall too far outside of the medical norm to meet this requirement.
Okay, but I just want to push on this, right? Because there's a statement that it's about the evidence, right? So this world where evidence is here, normativity is here, and it's okay because this is just all about the medical profession and the evidence, and is the evidence good or bad? Whereas I think the conversation about female genital cutting, the evidence piece is not where the contestation is. The contestation is about cultural defense. The contestation is about autonomy. Think about adult women, not young women, for example, where we're not talking about there might be concerns about coercion and the like, but a different construction, right? It seems to me it's normative all the way down, and we can't just say, well, as long as there's consensus or dissensus in the medical profession as an evidentiary matter, that solves the problem. We have to take stands on this and have views on it. And here's the kicker. Once a state does take a stand on this, it's a little hard for me to understand why they would give a prerogative to a medical professional. They wouldn't give a prerogative to an average person towards disobedience, right? And that we often say, when it comes to civil disobedience, part of doing civil disobedience is you have to stand willing to actually accept the punishment. That's part of what civil disobedience is. Why privilege the medical profession, people who tend to be higher socioeconomic status, who have a state-sanctioned monopoly, to get off with a slap on the wrist, where we would actually impose a much harsher sanction on the average person? What is it that gives this medical professional this extra privilege in this space?
Excellent challenge, bracing in the very best way. I would say largely it is obviously normative, and of course these are moral beliefs. But here's why I think they're different. Let me add one more example before actually answering your question. Aid in dying, I think, is not medically standard. There are some states that permit it. In 1991, a judge convicted Dr. Kevorkian for assisting in suicide. She gave him a very big sentence, but she said, recognize that medical norms evolve, and if this case were before me, in 20 years, I don't know how it would come out. Things change, and for better or for worse. So I acknowledge that these questions, the hard in-between cases, are absolutely morally inflected, culturally inflected, for sure. Here's what I think makes it different than any other moral belief or any other civil disobedience that we don't allow space for. It goes back to that standard of care. Now, it's not that that's perfect or that it's perfectly insulated from politics or ideology, to be sure, but I do think medicine is different. This is a profession in which people are explicitly charged, as that first medical ethics code from the AMA that I started with make clear, with their training and their practice for a few core basic tenets that I think for many people becomes a calling, a part of not just what they do or how they make money, but who they are, their defining moral commitments. And those are to heal patients, to promote their health, and to relieve their suffering. And I think that is and of course we disagree about how that applies at the edges to things like aid and dying and otherwise, but I think that we as a society can agree on basic medical standards of care that rely on and respond to emerging evidence and evolving norms that broadly support these three core goals of medicine much more readily than the vast majority of moral beliefs that are much more deeply divisive and contested.
Okay, good. But nice move, right? Your cases are the periphery, right? I'm interested in the core. I'll give fuzziness to the periphery. But let's take one of your core cases about abortion, right? A state says, you say it's about alleviating suffering and treating the patient. The state has a definition about who the patient is and how many patients there are in the analysis, and they decide that they ought to confer personhood interests in the fetus, right? Now, how do you say that, of course, squarely to honor the interests of the profession is to favor one over the other? I mean, certainly, once a state decides that, why give a prerogative towards disobedience to medical professionals that we wouldn't give to others?
All right, let's keep the fight going.
We'll let you have your fights in a minute. So after this interchange, go ahead.
Good. This is, I think, one of the most important questions before us today about the standards of care, because we have understood standards of care up until very recently as defined by medical experts. Judges here, medical experts duel it out in malpractice cases to determine whether a defendant, practiced above or below the minimal standards required for the profession. Medical standards of care arise from professional organizations or state medical board to say, this is what you have to do if you're in this specialty, in this kind of circumstance, and see this kind of patient. Now that's very complicated. We've got medical boards in Florida and many other states where they've been wiped out, and political appointees who say that vaccines don't work and conversion therapy is good treatment, and it's hard to see how that squares with the medical profession writ large or with the evidence at stake. You can also think that state, even maybe some national medical specialty organizations, are politically influenced. We saw, I think, more enthusiasm or embrace of gender-affirming care than we did in most other countries here, because it was thought, I think with some very good reason, that to do otherwise would erase the existence or acknowledge the respect of a deeply unpopular, small, insular group and population. But was that purely informed by the evidence from the start? Maybe we got ahead of our skis. And the core question is, who gets to decide? Is it doctors or a group of doctors or the organization of professionals who, again, underwent this training, have this moral charge to heal, to promote health, to alleviate suffering, who are expert in understanding and applying medical knowledge and their training? Are those the ones we trust to establish a standard of care? Or is it states that that feel differently about the vaccines and conversion therapy and gender affirming care and so forth? Is it judges like the Supreme Court justices who might decide whether to honor Colorado's view that the standard of care requires barring conversion therapy? Who decides? Now, I don't think any of these people are perfect, or any of the institutions. This is a matter of comparative institutional competence. And I think that medical professionals as a body, as a whole, are better situated, comparatively speaking, than lawmakers or judges who would speak for them to redefine standards of medical care that the trained medical doctors who aren't captured by political interests and partisan appointments have done. They've made huge mistakes before. We've talked about some of them. These are not, they're outliers, but there are others. The tendency of slaves to run away, that was a disease. So was the tendency of wives not to want to have sex. If you didn't want to be raped by your husband, a disease. We need to medicate you for that, treat you for that. We've gotten it horribly wrong before. That was the medical establishment that stood behind those diagnoses and the treatments accordingly. It's not that it's perfect. Justice Alito tried to raise this in the...
We have some time for questions from the audience, so let's switch to that. Yes, and then back there.
You kind of say states like it's a dirty word.
You say states like it's a dirty word.
Yeah. Oh, did I?
Deciding something is this terrible, scary outcome.
Oh.
But and it might be in some circumstances, but it is the democratic process, and you're just kind of shoving the accountability onto some different group that doesn't have any democratic control. So we can be concerned if the democratic process isn't working, but wouldn't we rather have at least accountability through the democratic process versus giving this power to completely unaccountable medical boards that, to your point, have made terrible decisions, and you have all these examples of bad outcomes. Like either party can make bad outcomes, but one seems much more accountable to the people. And is that not a reason to leave it to the people?
It's a great point. I like democracy. And democracy is supposed to be about accountability and representing our interests and our representatives who answer to us in votes and elections. And yet the judiciary has historically performed a very important function, I think, when there are profound harms that go unrecognized in our laws, as slow as they work, as difficult as it is to achieve structural change through those democratic processes, where judges can step in. We didn't have, when the penny press first came along, yellow journalism, and people were taking, nude photos of people through their bedroom windows or scandalous gossip about them in the front page. We didn't have something called the right to privacy. It was judges who invented a common law right to enable people to sue against, the newspapers that would put their intimate private details in the papers. And legislatures then came along in successive decades and did that, but it was the judges who stepped in. So that's what I'm proposing. And I think it's squarely within the ordinary role, sentencing authority and defenses to do that work where I think that's appropriate here. It would also even things out that we already recognize, a conscience regime that is squarely in place but deeply unprincipled. And I think in ways that are harmful for patients and that violate these core values of patient care and medical access. I think I deeply respect states' interests to adopt positions that I deeply disagree with, and I think many do. And it's very important, I think, to respect those democratic systems. But right now, when patients are dying and clinicians are experiencing deep moral distress that their colleagues on the refusing side don't have to endure for a reason that I don't think is justified, then we would do well to balance out these protections in ways that I think would promote pluralism better and would not defeat states' interests, but serve them. It's not states that are bad, to be sure. I think it is work that undermines the standard of care, reliable evidence, and the profession of medicine to do the deeply moral work that it does and that we value. I would say also states have special reason to regulate clinicians because they've got kind of a deal with doctors. They license them to give them a very special privilege of having a monopoly over selling their services. It used to be that anybody could come off the street and sell, medicine or surgeries, a chiropractor, midwife, hocus pocus, voodoo, whatever. Anyone could do that, and it wasn't that lucrative to be a clinician, to be licensed in order to do these things. And then we said, well, maybe it's not a great idea, and we're going to give all the power to medical schools and the state medical boards to issue these licenses. And that license means you get to have a pretty well-paying job because you're insulated from competition. Only you get to provide this care and do this work. No one else can. If someone else does, we'll throw them in jail for practicing medicine without a license. And in exchange for that privilege, states said, at least until recently, that you have an obligation to abide by medical standards of care. We're going to enforce rules that say, well, you've got this very lucrative monopoly to practice medicine, and in exchange, you have to practice according to certain standards, and failure to do so means you can lose your license. And so I think the states have a very important role in licensing these professionals to recognize the obligations that they owe and to provide the social value of health and the relief of suffering and healing that is a social value tantamount to military defense. I think one that is a great need that society ought to regulate and govern and care about through state democratic laws and otherwise in ways that don't lose a sense of what medicine is for and why we care about it.
Let's try to sneak in at least one more question if we can. Up here, go ahead. In the front, I think there was one.
Hi, thanks for your talk. I want to push you a little more about the role of evidence, especially when contrasting the medical professional society population level data to make a blanket policy recommendation versus a patient individual in front of an individual provider. Do you think that there's some wiggle room for something like body integrity identity disorder where there might be like specific reasons to think that this isn't actually just a harm reduction, this is actually beneficial for the individual patient?
Yeah, I do. I wouldn't provide an exception in the conscience defense for the democratic reasons that the questioner before you asked about. But I do think there are lots of individual patient-specific reasons. I mean, medicine is not just a science, it's an art. We give people discretion in this role to exercise their best judgment at the bedside to make determinations based on extraordinary variations, not just among patient conditions and health statuses, but also patient values. Evidence can take form in lots of different ways too, not just double-blind placebo studies, but also long-standing clinical practice, or like we saw with the vaccines in the public health emergency during COVID-19 crisis, the biological plausibility of something that could work, but we don't have time to test out in the ways that we usually do. So evidence emerges over time. I think there are lots of different forms that it can take, and then to apply it in specific cases can absolutely, of course, vary based on individual circumstances. That happens all the time. But I don't think that for something that is so far afield of the medical norms as removing a healthy limb ought to qualify for a defense for breaking the law. That said, I am open to the possibility that our norms, medically and otherwise in society, could change over time, just like that judge who convicted and sentenced Dr. Kevorkian suggested might be the case with medical aid in dying for all kinds of things. I am ashamed in advance for all the things that our grandchildren will look back on us and think, what were you doing? And think back on things like contraception, abortion, aid in dying, long, and in so many emerging conflicts, not just these controversies of our time, but the ones that lie just over the horizon and far ahead that we can't foresee. In ways that I don't know which direction things will go or how they will take shape, or whether we'll appreciate a second patient in the form of the nascent life growing inside of someone as independent. I don't wish to foreclose these options off or say that we have the answers right now today or in certain states and not others, but rather to be open in a in, I think, a way that requires moral humility and social deliberation. That is what I think conscience is about. It promotes, demands that kind of openness to promote this pluralism that says we don't necessarily have all the answers, not us ourselves as opposed to others, and not us today as opposed to future generations. That's why we respect the deeply held moral views of those with whom we deeply disagree in order to make space within the structure that nevertheless abides by certain rules about things like patient care and basic access that we can uphold together, I think.
Please join me in thanking Professor Fox for reading the book.